Wolf Theiss Soundshot. Insights and analysis from one of the leading law firms in Central, Eastern, and Southeastern Europe.
Hello, everyone, and welcome to another episode in the Digital Law Podcast series where we discuss various legislative initiatives coming from Brussels as part of the EU digital strategy. My name is Klara Miletic. I'm a partner in IPTMT Practice Group and I'm based in Ljubljana, Slovenia.
And my name is Flavius. I'm a counsel in the IPTMT practice group based in Wolf Theiss office in Bucharest, Romania.
And the topic of today's podcast is the interrelationship between GDPR and various acts that form part of the EU digital strategy. But before we jump into the topic itself, a few words on the digital strategy.
Thanks a lot for the introduction, Klara. As you know, in the last decade, the European Union has taken a leading role in creating laws to protect personal information. And the most notable of these laws, I would say, it's the GDPR, which had a great impact in practice. With its EU digital strategy, as announced in 2020, the EU aimed to expand its existing framework with some additional rules that go beyond personal data and even data in general. The EU digital strategy contains new regulations to encourage data flow, to encourage data access, and the data economy, introduced through the Data Act and the Data Governance Act. These rules, in contrast to the GDPR, apply both to personal and non-personal data, including machine-generated and product-related data. Additionally, the EU is also implementing stricter requirements and enhanced user protections for online platforms, hosting services, search engines, online marketplaces, and social networks through the Digital Markets Act and the Digital Services Act. Artificial intelligence is also a significant focus of new regulations coming from Brussels. And furthermore, business providing IT-based services should pay attention to the proposed ePrivacy regulation. Some of the new regulations aim to create a single data market, facilitating data sharing and access for companies, while others focus on ensuring a secure digital environment for service users.
If you're looking for an overview of these acts, you are welcome to listen to earlier episodes on the Digital Law Podcast series, where our colleagues discuss the Data Act, the AI Act, and the DSA. But today, Flavius and I will discuss how these acts interplay with the GDPR. Individuals' right to protection of personal data has a special place in the EU law, since it is protected already by the EU primary law, more specifically the Treaty on the Functioning of the European Union, as well as the Charter of Fundamental Rights of the EU. So, on this basis, a comprehensive data protection framework has been adopted, notably the GDPR and the Privacy Directive. And these new regulations that we will discuss today have to comply with the GDPR, of course, where the personal data is processed, and have to be read in conjunction with the GDPR. So let's start where the biggest buzz is right now, with the AI Act. Flavius, what is the AI Act relationship with the GDPR?
Well, I would just start with a few words in introduction. Most of our listeners already know this, but I would like to point out that on 13 March 2024, this year, the European Parliament plenary session formally adopted at first reading the EU AI Act. The final version of the EU AI Act is now expected to be formally adopted in a few weeks' time. We were told that we should expect minor linguistic changes, but however, the final version seems to be still under the discussions, and it seems that the minor language adjustments are a bit more important than it was foreseen. However, we should have a final version in a few weeks' time, and we will have the first complex regulation of AI systems in the European Union. The main purpose of the EU AI Act is to provide for the safe technical development and use of AI systems. With minor exceptions, this AI Act does not create any specific rights for individuals. On the other hand, the GDPR creates or created an extensive range of rights of data subjects in relation to the processing of the personal data. As such, the EU AI Act and the GDPR are somehow designed to work together. The AI Act will be the general law that will regulate the development and deployment of AI systems, while the GDPR will become applicable in cases where AI systems use data related to living persons, to data subjects. The GDPR is a technology neutral regulation, I would say, and as the definition of processing of personal data under the GDPR is very broad, and in practice, it includes nearly all activities conducted on personal data, including data storage. It somehow becomes obvious that the GDPR applies to AI systems to the extent that personal data is present somewhere in the life cycle of AI system. From a technical perspective, it is somehow very difficult to separate personal data from non-personal data, and this increases the likelihood, I would say, that AI systems process personal data at some point in their life cycle. While AI is not explicitly mentioned in the GDPR, the automated decision-making framework included in the GDPR serves as a form of indirect control over the use of AI systems on the basis that AI systems are frequently used to take automated decisions that impact individuals.
And is there any connection or correlation between the human oversight under the AI Act and the automated decision making under the GDPR?
Under the GDPR, data subjects have the right not to be subject to solely automated decisions involving the processing of their personal data that would result in legal or similarly significant defects. Where such decisions are taken, they must be taken on one of the grounds set out in the GDPR, namely with the consent of the data subject. Like the GDPR, the EU AI Act is also concerned with ensuring that fundamental rights and freedoms are protected by allowing for appropriate human supervision and intervention, the so-called human in the loop effect. The EU AI Act requires high-risk AI systems to be designed and developed in such a way, including with appropriate human-machine interface tools, that they can be effectively overseen by natural persons during the period in which the AI systems is in use. In other words, providers must take a human oversight by design approach, let's say, when developing AI system. According to the same proposed EU AI Act, the deployer of the AI system must take appropriate technical and organizational measures to ensure its use of an AI system is in accordance with the instructions of use that come with the said systems, including with respect to human oversight. The level of human oversight and intervention exercised by a user of an AI system may be somehow determinative in bringing the system in or out of scope of the automated decision-making framework under the GDPR. In other words, I would say that a meaningful intervention by a human being at a key stage of the AI system's decision-making process may be somehow sufficient to ensure that the decision is no longer wholly automated for the purposes of the GDPR. More likely, AI systems will be used to make wholly automated decisions, but effective human oversight will somehow operate as a safeguard to ensure that the automated decision-making process is fair and that an individual's rights, including their right to data privacy, are upheld.
That's a very interesting point. And while the AI Act will not apply for some time yet, the AI systems targeting users in the EU have to comply with the GDPR. Just recently, NYOB, the European Center for Digital Rights, reported that they filed a complaint to the Austrian DPA against OpenAI due to their failure to respect several data users' rights granted under the GDPR. The complaint was filed on behalf of an unnamed complainant. The EU law requires that personal data is accurate, and the individuals have a right to rectification if data is inaccurate, and they can request that false information is deleted. Also, under their right to access, companies must be able to show which data they hold on individuals and what the sources are. So in this case, ChatGPT, when asked about the complainant's date of birth, repeatedly provided incorrect information. And when the complainant filed a request to rectify or erase false personal data, OpenAI refused the request, stating that it wasn't possible to correct false data about an individual on ChatGPT. OpenAI also failed to adequately respond to the complainant's access request. When asked for a copy of personal data that it processed about the complainant, OpenAI failed to disclose information about the data processed, its sources, or its recipients. So as a result, NYOB filed a complaint to the Austrian DPA. And we will see how this case plays out, but we can expect more complaints like this in the future, I think, following Garantes, that's the Italian DPA's temporary block of ChatGPT in 2023. Even the European Data Protection Board, EDPB, set up a task force on ChatGPT to coordinate the national efforts. And what about the Data Act? Flavius, can you explain what is the purpose of the Data Act?
In a nutshell, the Data Act obliges legal or natural persons who qualify as data holders to share data collected with others in the value chain through connected products, related services, and virtual assistants. Connected products, to start with, are often referred to as the Internet of Things, IoT, and these are items that obtain, generate, or collect data concerning their user or environment, and that are able to communicate product data, for example, via an internet connection or through telephone networks or through NFC, and whose primary function is not the storing or processing or even transmission of data on behalf of any other party other than the user. Related services generally refers to digital services other than those related to electronic communication services and software, which are connected to the product from the outset in such a way that the connected product would not work without them, or are subsequently added to improve the functionalities of the product. On the other hand, virtual assistants would mean software that can process demands, tasks, or questions, including those based on audio, written input, or motions, gestures, and that based on such demands, questions, or tasks can provide access to other services or can control the functions of connected products.
So, how will the Data Act be applied in conjunction with the GDPR? While the GDPR focuses on personal data processing, the Data Act regulates access and sharing of product data, related services data, and metadata, either personal or non personal. And the GDPR will take precedence over the Data Act when personal data is processed. But what is also important, the Data Act provides that it does not constitute a new legal basis for the access or sharing of personal data by the data holder. Legal basis when it comes to personal data must be determined under the GDPR. So let's look at some of the ways the GDPR and the Data Act overlap. The Data Act introduces users' access right and right to share product data and related services data with third parties. When it comes to users' access rights to data under the Data Act, it complements the right to access own personal data under the GDPR. But it is broader since it also covers non personal data and, if possible, access in real time. And in terms of who can exercise the right under the GDPR, it's only the data subjects, the individuals, while under the Data Act, it's the users. So any legal or natural person who owns, rents, or leases the connected product or related service.
Clara, I would have a question here. What happens if the user who makes the request is not the data subjects? How would this happen in practice?
This is a very good point because when the user is not the data subject whose data is requested, for example, when the user is a legal entity that owns the connected product and the product is used by the individuals like the employees, then the Data Act makes it specifically clear that the data holder may only make personal data available to the user if there is valid legal grounds under the GDPR. Remember, we said before the Data Act does not establish new legal basis for the processing of personal data. But it's not entirely clear how, in practice, the legal basis will be verified by the data holders. Will it be sufficient if they rely on the user statement that such legal basis exists, or will stricter obligations apply? This may be something that will need to be clarified by the supervisory authorities or the courts. And the second key right the users have under the Data Act is the right to share data. Some call it the super portability right. The data holders must grant access to data to third parties if users request so, or if the users authorize third parties to make such a request. Again, the portability right here is broader than under the GDPR since it extends also to non-personal data. It allows the sharing of data directly with third parties, and it's the user who can exercise a right, not just the individual data subject. And as with the access right, when the user is not the data subject whose data is requested, valid legal grounds under the GDPR for the sharing of data is required.
Klara, I have another question here. I wanted to ask you whether the Data Act somehow clarifies the roles of the parties which engage in data processing. Do we have something similar like in the GDPR, or does the Data Act not mention this at all?
That's a very good point. The Data Act provides limited guidance in this respect. In its recitals, it provides that when the user is not the data subject but an enterprise, including a sole trader, the user is considered to be a controller. But what about the data holder? Is then the data holder a processor? Well, in some instances, it says the data holders and users may act as joint controllers. In this area, however, there's a certain level of ambiguity, so data holders and users will need to define their roles based on the GDPR and their actual roles in relation to the personal data processing activity. And there are other areas that we haven't touched on, like the chapter on business to government sharing of data in case of public emergency and more. But I think we can conclude here with the Data Act and move to the DSA.
Indeed, and the DSA is a very important piece of EU legislation, I would say. As most of our listeners probably already know, the Digital Services Act is a very comprehensive legislation. It's designed to regulate digital platforms, including large online platforms and search engines. So it applies to the largest players on the market, and it creates important obligations for them. It's aimed to enhance safety and accountability online. The DSA requires platforms to be transparent about their content moderation processes, about the decision making on advertisement, and the operation of recommendation algorithms. Other key provisions of the DSA include requiring systems for users to report illegal content online, and requiring clear explanations for content removals, regular risk assessments by large platforms to address the potential spread of illegal content and the impact on fundamental rights where necessary mitigation measures are in place. Another important obligations is related to the enhanced transparency in advertising, allowing users to understand the reasons behind targeted ads while prohibiting targeting based on sensitive criteria such as ethnicity or political opinions. And another important aspect would be safeguarding minors from harmful content and misleading ads. The Digital Services Act, I would say it aims to complement the rules of the GDPR in order to ensure the highest level of data protection. As you know, the GDPR somehow acts as a shield for personal information, and it establishes a comprehensive framework for how data controllers can collect, use, and protect data of data subjects. This includes granting individuals a range of rights over their data. As I mentioned before, the GDPR creates very important rights of individuals, such as the right to access, the right to rectify the data, the right to erase the data. And the GDPR also ensures transparency, empowering users to gain control over their data and over their digital footprint. The DSA, somehow in contrast to the GDPR, takes a broader approach, and it aims to create a safer and more trustworthy online environment for EU users. But not specifically by enhancing users' right, but rather more by tackling illegal content, by tackling spread of disinformation, by limiting all sorts of unfair practices by online platforms like social media platforms and marketplaces. The DSA somehow obliges these large players, these platforms to increase content moderation efforts, and the DSA is trying to hold large players accountable for the content that they host. We had in the previous legislation, we had some sort of liability for the hosted content, but the DSA increases this accountability for this content and increases the obligations of the large platforms. Um, this somehow fosters a responsible online ecosystem. There is an area of intersection of the DSA and the GDPR, which particularly concerns online advertising. The DSA prohibits the practice of targeting advertisements based on sensitive personal data categories protected by the GDPR, such as race or religion. And in this particular case, the DSA and the GDPR work in tandem to strengthen user privacy protections in the digital environment.
Indeed, and another area of overlap is the targeted advertising and the protection of minors. The GDPR provides in its recitals that the automated decision making, including profiling, with legal or similarly significant effects, should not apply to children. And this is relevant for any context, actually, not only online platforms. The DSA builds on this protection by prohibiting the display of ads based on profiling that uses personal data of users when they are aware with reasonable certainty that the recipient of the service is a minor. So while determining whether the user is a minor, the data minimization principle under the GDPR should be applied. And as mentioned before, a significant area of overlap between the DSA and the GDPR relates to transparency. Transparency as to how personal data is processed is one of the basic principles under the GDPR. The DSA aims to increase the overall transparency related to online platforms. For example, it imposes on the providers of online platforms transparency obligations related to how the recommender system works. Online platforms should consistently ensure that users are informed about how recommender systems impact the way information is displayed and can influence how information is presented to them. Additionally, very large online platforms, VLOPs, and very large online search engines, VLOCs, they must provide at least one option for each of the recommender systems, which is not based on profiling. And speaking of online advertising, Flavius, what is the status of the long expected e-privacy regulation, and how will this new regulation interplay with the GDPR?
Well, Klara, as you know, this is a very debated subject, let's say. The European Commission first proposed the privacy regulation in January 2017, and at that point, it was somehow expected to take effect alongside the EU GDPR. So in May 2018, and we're in 2024 now, and this has not happened yet. The final text is still to be agreed with the Council of the EU, and the European Parliament and the Council of the EU are disagreeing currently about a number of issues, and there have been a lot of discussions on this topic. It was somehow intended that this privacy regulation would complement the GDPR's general rules on personal data processing by providing specific rules governing electronic communications, and it was aimed to replace the current electronic communications, the ePrivacy Directive. The ePrivacy regulation is somehow aimed to take precedent over the GDPR in situations where both laws apply. And unlike the GDPR, the ePrivacy regulation would not only apply to personal data, but it would also affect B2B marketing, for instance. The final text is yet to be agreed. We don't know when this will happen, but the Council's draft recommends that the regulation applies to processing of electronic communication communications content and metadata carried out in connection with the provision and use of electronic communication services. It would apply to end users' terminal equipment information, namely to cookies and pixels and technologies like that. It would apply to the offering of a publicly available directory of end users of electronic communication services and to the sending of direct marketing communications to end users. Whatever the regulation's final wording, it will most likely have the same territorial scope as the GDPR and would apply directly in all EU member states, as well as having extraterritorial reach to non-EEA organizations, similar to the GDPR that would process EU residents' data of electronic communications content, metadata, that would process EU residents' terminal equipment information, that would offer publicly available directories of EU residents, or that would send direct marketing communications to EU residents.
We see more and more potential use cases where AI and IoT devices work together. Flavius, does this raise any risks in relation to personal data? What would you say?
Indeed, the integration of AI and IoT devices would present several risks related to personal data, but this is the main reason why we're talking about all these laws and regulations, which would somehow minimize the risk and would be somehow applicable to some extent to AI and IoT. One risk, or the most pregnant risk, I would say, would be increased data collection, because as you know, IoT devices such as maybe smart home systems, wearable health trackers, connected cars, all of these devices would collect a large volume of personal data. And when combined with artificial intelligence, these devices can process and analyze data at a deeper level and could reveal a lot of personal insights and patterns about individuals. There are data security risks. IoT devices are often less secure than traditional computing devices, and this would make them vulnerable to cyber attacks. As you know, on your personal computer, you would have an antivirus software installed and you could enhance the protection, but on a lot of IoT devices, you don't have the possibility and you would just need to rely on the cybersecurity features that are embedded in the IoT device. You can't install antivirus software on your washing machine, for example, or on your fridge, but I think in the future we will see that at some point. So when AI processes personal data from these devices, security breaches can lead to sensitive information being compromised, and this could raise concerns about identity theft, maybe, but most likely concerns related to unauthorized access and data manipulation. There are also some ethical considerations to be taken into account. The combination of AI and IoT can raise ethical concerns, especially when used in sensitive areas like healthcare, surveillance, or personal behavior monitoring. To address these risks, because there are also certain solutions, not only risks, the organizations would need to adopt robust data protection practices that can include maybe implementing strong security measures to protect IoT devices and the data they collect, to ensure transparency, explainability in AI operations, which could allow individuals to understand how the data is being used, to obtain clear and informed consent from individuals when the case may be, to establish robust compliance frameworks in order to meet legal and regulatory requirements, and to conduct regular risk assessments in order to identify potential vulnerabilities in AI IoT systems and to mitigate them effectively.
This is all we have prepared for today's podcast. We refer to a few areas of interplay with the GDPR, but there are many more, so close read of these new regulations with the GDPR is required. Flavius and I will follow this topic closely and may even revisit it in the future, but for now we say goodbye and thank you for listening.
Thank you for joining us for today's episode of Wolf Theiss Soundshot. For more information, you can contact us via email at soundshot@wolftheiss.com or visit our website at www.wolftheiss.com.